Should we go ahead and get started?
Yeah.
Yeah?
Let's go ahead and get started.
Okay. Well, thank you everybody for coming. And I was going to thank Jordan, but I don't see him anywhere.
He's going to be here, but he's on his way.
All right, well, thank you for having me. You guys put on some really great events, so I'm excited to be a part of it. And tonight I'm going to talk about legal barriers to research on Schedule I controlled substances. I think a good place to start is with some definitions. So we'll talk a little bit about why we have laws, where they come from, how they're interpreted and enforced, and also what it means for a drug to be categorized as Schedule I. So bear with me for what may seem like some elementary remarks, at least initially, but I think it'll be helpful to the discussion. So I like this definition of law. Laws are rules made by a government to order the way in which society behaves. And this definition implies that there's some amount of power exerted by the government over the population through laws. And we've had laws for thousands of years. They've been tools of pharaohs, kings, and emperors to control their people, to consolidate and expand their power. And today, with the exception of some dictators, we like to think that we have more altruistic ends in mind when we make laws. And hopefully our laws can safeguard society and even promote public health. So I want to talk a little bit about where laws come from. In the United States, we have a separation of power that sort of spreads the power granted to the government out over several disparate bodies, so it's not consolidated in any one place. And the Constitution created three separate branches to the federal government. We have the legislative branch, made up of the House of Representatives and the Senate, and that Congress drafts and implements our laws. And then we have the executive branch, led by the president and made up of several administrative agencies like the Food and Drug Administration, the Environmental Protection Agency, and the Department of Justice. And that executive branch enforces our laws. And then finally, we have the judicial branch, led by the Supreme Court and made up of numerous federal, district, and appellate courts. And they interpret the laws. And when we think of laws on the books, we typically think of the laws made by Congress. But in reality, all three of these branches of government create rules that order the way in which our society behaves. So, for example, the executive branch, through its administrative agencies, creates administrative rules. They don't have the same force of law as the laws created by Congress, which are considered the supreme law of the land and take priority over all other laws, like state laws. Still, administrative rules are binding on us, and they do shape our behavior and the behavior of our institutions. Then finally, the judicial branch, through its court decisions, creates legal precedent, which is also known as common law or judge-made law, and that too shapes our behavior. It binds future court decisions, and it also influences the behavior of corporations and other groups. Now, one law in particular is relevant to the regulation of controlled substances, and that's the Controlled Substances Act of 1970, or the CSA. And prior to the 60s and 70s, there was really just a patchwork of laws regulating drugs in the US, and they primarily dealt with drugs like heroin and cocaine. And at this time, the Drug Enforcement Agency did not exist, and an act of Congress was needed in order to regulate a drug. So Congress actually had to pass a new law in order to regulate a new drug. The CSA is really thought of as a turning point in the history of US drug law. It was intended to modernize our drug laws, harmonize the different agencies that engage in drug control, and it created an administrative structure that could regulate drugs without the need for congressional action, so without the need for Congress to actually go in and create a new law. The CSA granted the Attorney General, our top law enforcement officer, the power to categorize a compound into one of 5 schedules. And these are the 5 schedules of controlled substances that you might be familiar with. And drugs are categorized into these schedules based on their safety, their medical utility, and their potential for abuse. It's kind of interesting that the power to make public health decisions was granted by Congress to our top law enforcement officer. In this case, is Jeff Sessions. And the Attorney General is typically a position that does not have any scientific, medical, or public health experience. And that decision probably reflects what was going on in society at the time. In the 1960s, drug use was associated with cultural rebellion, and Congress and later President Nixon were trying to crack down on drug-related offenders. There was a lot of fear regarding drug-related violence. In 1971, President Nixon said that drug abuse was society's public enemy number one. And 3 years later, after the CSA was passed in 1973, Nixon issued an executive order that created a new agency, the Drug Enforcement Agency. And since then, attorney generals have usually delegated their scheduling power to the DEA. Most of the people in this room are probably pretty familiar with the schedules, and you may prescribe controlled substances on a regular basis. And you know that drugs in each category are regulated differently. So for example, if you want to prescribe a drug in Schedule 3 through 5, that prescription can be transmitted to a pharmacist by almost any means. It can be verbal, it could be transmitted by fax or in writing, and you can have multiple refills on those prescriptions. Schedule 2 drugs are a little more tightly regulated, and a prescription, with some limited exceptions, must be transmitted to a pharmacist in its original written form, and you cannot have refills on those drugs. And Schedule 1 is the most tightly regulated category. Drugs in that category are deemed by the DEA to have no currently accepted medical use. That's sort of a hallmark of Schedule 1 drugs, and that's a concept that I want to return to a little later, currently accepted medical use. These drugs cannot be administered or used outside of a research context, and they require special licenses from the DEA. So what exactly is required in order to schedule a drug? How does a drug go from being unregulated like coffee or tea to becoming a controlled substance like marijuana or MDMA? What happens is when the Attorney General is considering whether to schedule a drug, he's required by the CSA to commission a study from the Secretary of Health and Human Services, who typically delegates that responsibility to the FDA. And in making that determination, the FDA will use these 8 factors that were elaborated by the CSA. And you can see that most of them have to do with the potential for abuse or dependence. Some of them have to do with our scientific understanding of a drug, like its pharmacology, and one of them has to do with public health risk. It's interesting that they're all sort of geared towards the negative aspects of the drug. None of them address potential benefits or positive uses of the drug. So it's just kind of interesting that they frame it in a negative way. And I want to talk about an example of a drug that's currently being considered by the FDA and the DEA for Schedule 1. And it's very likely to end up there, I think. This is a plant called mitragyna speciosa. It's more commonly called kratom. It is indigenous to Southeast Asia, primarily Indonesia, Malaysia, and Thailand. And it's been used there for hundreds of years. People typically chew the plants orally, and they try to get, they use it for its effects, which appear to be dose dependent. So at lower doses, it has a mild stimulant effect, and workers will often consume the drug in an attempt to stave off fatigue, much in the way that we would consume coffee or tea just to stay alert at work. At higher doses, it has more of an analgesic opioid-like effect, and for that reason, it's been used in Asia to treat pain or to help ease symptoms of withdrawal from opium. It's gaining momentum here in the United States for treating pain and for easing withdrawal from drugs like heroin and prescription opioids. Here in the US, the leaves are typically turned into a powder or brewed into a tea and consumed. And it's been used in the US for about 2 decades or so, maybe a little longer. There are 25 different alkaloid compounds in kratom, and these are the 2 predominant chemicals that have physiologic activity, mitragyne and 7-hydroxymitragyne. And they have activity on some of the same receptors as typical opioids, specifically the mu opioid receptors, and I believe to a lesser extent the kappa and delta opioid receptors. And that is believed to be what makes them useful for treating pain and what is responsible for their analgesic effects. It's also gathering attention from the DEA and FDA, and these compounds are increasingly under scrutiny from those agencies. They're actually illegal in Thailand, though widely used there. And technically on the federal level in the US, they are legal. You can buy them. You can buy kratom at retail stores across the country, even in many gas stations. There are some states that are starting to outlaw it, like Tennessee, Alabama, have passed laws to make it illegal, and other states are looking at that. Last year in August, the DEA announced that it intended to temporarily place kratom in Schedule 1, and it's allowed to do that because the Attorney General has the power to categorize a drug in Schedule 1 for a period of 2 years if he believes that it presents an imminent hazard to public health. And in response to that announcement, there was a large public outcry from kratom users and from advocacy groups like the American Kratom Association. And they claimed that there was no scientific basis for the risks that the DEA was associating with kratom. The DEA mentioned 15 deaths that it said were associated with kratom between 2014 and 2016. Some members of the Senate and Congress also got involved in this debate. There was a letter drafted by Congressman Mark Pocan and Matt Salmon and signed by 51 different congressmen asking the DEA to delay its scheduling so that there could be a period of public comment and more evidence could be gathered. And sort of incredibly, the DEA actually listened, and in response, in October of last year, it announced that it was no longer planning to schedule kratom, at least for the time being. Now, a month later, in November of last year, a pharmaceutical consulting firm called Piney Associates conducted its own analysis of kratom using those 8 factors that were elaborated in the CSA. And I won't go into the detail of the analysis, but you can find it on the Piney Associates website. And it was conducted by Jack Henningfield, who is an expert on clinical pharmacology and addiction. And he's currently an adjunct professor at Johns Hopkins Medical School, and he used to be in charge of the clinical pharmacology unit of the National Institute on Drug Abuse. So he has a pretty impressive pedigree, and he definitely has a lot of experience in addiction science. And he found that kratom had low toxicity. Its risks of serious adverse events was low, especially compared to traditional opioids. And Henningfield said that there were no deaths that could definitively be attributed to kratom. He pointed out that of those 15 deaths that the DEA mentioned, they were including 9 deaths that occurred in Sweden, and those people apparently consumed a mixture of kratom and O-desmethyltramadol, which is an active metabolite of the opioid tramadol. And that mixture is called Krypton, and it's something that people can actually purchase online. And these 9 people apparently purchased the drug and unfortunately died. According to Henningfield, the other people in that 15 also were consuming combinations of drugs with kratom, like benzodiazepines, alcohol, or opioids like fentanyl. So he sort of debunks this idea that kratom itself is the cause of these deaths. He did acknowledge that there is potential to develop physical and psychological dependence on kratom, but he said that this is really similar to the dependence that people develop to caffeine. And ultimately, he concluded that outlawing kratom would really just serve to create an illicit black market for the drug that would increase the likelihood that users would be exposed to adulterated or contaminated batches of kratom. And he said that it's not in the interest of public health to schedule kratom. He is in favor of some regulation just to make sure that what people are purchasing is pure and it's safe. He just doesn't believe that it should be on the controlled substances list. 1 year later, last month, the FDA issued an advisory on the deadly risks associated with kratom. And Commissioner Scott Gottlieb said that the FDA is very concerned that people believe that they can use kratom to help them treat symptoms of opioid withdrawal. He even suggested that kratom use could actually contribute to the opioid crisis instead of helping to address it. About 2 weeks ago, Jack Henningfield responded to the FDA advisory at a press conference held by the American Kratom Association, and he said that the commissioner did not understand what many kratom users already know and what the science suggests, that kratom use is actually a path away from opioid use, not towards it. This debate is particularly important right now as we are in the midst of an opioid crisis, and these are the current statistics on drug-related deaths. And you can see from looking at this graph that deaths associated with heroin, for example, have more than tripled since 2010. And if you look at the blue line in this graph, that is the sharpest rise in opioid-related deaths, which has occurred in the past few years, and that's due to fentanyl and other synthetic opioids. Interestingly, that's actually excluding methadone. Methadone has its own little graph there, and it was actually responsible or associated with over 3,000 deaths last year. So when we look at the risks associated with kratom, it's important to think about it in context. Even methadone, which is part of MAT, or medical assisted therapy for opioid abuse, is responsible for thousands of deaths each year. Earlier this year, President Trump created an opioid commission, and he appointed Governor Chris Christie to lead that group. And in the commission's final report to the president, the group said that over 100 people are dying every day in the United States from opioid overdose. And I've seen different statistics, as low as 91 and as high as just over 100. And in that report and in his testimony to Congress, Christie said that if this many people were dying at the hands of a terrorist organization, we would do almost anything. We would pay any price to stop it. And in that spirit, I think we need to look at drugs like kratom. If there's any potential for it to curb these rising death rates, it needs to be considered. And the problem is that if it is placed into Schedule 1, it will be extremely difficult for researchers to do any research on it at all. And we may never truly understand its risks and benefits. I argue generally that when drugs are placed into Schedule 1, they are effectively lost to science. I think of it as sort of a regulatory black hole where drugs go into Schedule 1 and they rarely ever come out. And part of the reason for that is that they become stigmatized. And so people become afraid to discuss these drugs in public. They become afraid to use them, which could be a good thing depending on the drug and the particular use you're talking about. But imagine that a clinical trial does somehow get off the ground. The stigma could discourage people from enrolling in that trial. Similarly, professionals like physicians and scientists may be hesitant to conduct research on Schedule 1 drugs out of fear that it could tarnish their reputation or somehow affect their position. There are also significant regulatory barriers that are raised when a drug is placed in Schedule 1. To give you an example, last year the DEA announced that it would open up applications to grow marijuana for medical research. And prior to this announcement, marijuana for research could only be grown on a federally sanctioned farm on the campus of the University of Mississippi. And the marijuana grown on that farm was well known among researchers to be of relatively poor quality, and there was a very small range of strains that were grown on that farm. So this announcement was an opportunity to increase the variety of marijuana strains that could be studied and increase the quality of plant material provided to researchers. But a year after that announcement was made by the DEA, despite the fact that it had received over 24 applications to grow marijuana for research, none of those applications were granted, and I believe even today none of them have been approved. So if kratom is put into Schedule 1, it may be extremely difficult to get a license from the agency to study it. There are also large economic barriers to studying Schedule 1 drugs. The Multidisciplinary Association for Psychedelic Studies, or MAPS, is currently conducting 2 phase 3 clinical trials on the use of MDMA, assisted psychotherapy, to treat PTSD. And MAPS estimates that the cost of those 2 trials will be about $25 million. And a large portion of that cost is dedicated to regulatory compliance. They have to hire attorneys to submit the application and handle all of the agreements. There are also very stringent requirements regarding records and storage of the drug. All of these requirements result in a very high cost that could be insurmountable for all but the most well-funded researchers or organizations. Then when marijuana was legalized in California for medical use in 1996, with the Compassionate Use Act, the federal government threatened to revoke the DEA licenses of physicians that recommended marijuana to their patients. And that is still potentially having effects today. Professionals may be hesitant to get involved in psychedelics research out of fear that they could lose their medical licenses. Attorneys have also been afraid to represent marijuana clients out of fear that they could lose their state licenses to practice law. This stigma and these concerns do seem to be decreasing, especially in the past 10 to 20 years, but it's still an effect. Finally, I mentioned that Schedule I is sort of this regulatory black hole, and drugs rarely leave that category once they're placed there. The DEA has actually only rescheduled drugs from Schedule I 5 times in its approximate 40-year history. And part of the reason for that is that in order to reschedule a drug, it must be shown that it is safe and efficacious. And I'll explain in the next few slides why I believe that the standards to establish safety and efficacy are too strict and applied too rigidly. So I want to talk briefly about rescheduling. Right now, if you want to reschedule a drug, there are 2 general pathways for doing that. There's a legislative path in which Congress can pass a new law and reschedule a drug directly, or they could amend the relevant sections of the CSA to reschedule a drug. Alternatively, there's an administrative path through the executive branch, and the Attorney General has the power to unilaterally reschedule a drug. So technically, Jeff Sessions could wake up tomorrow and say that he was going to reschedule marijuana. The head of Health and Human Services can also petition the DEA to reschedule a drug, or really any interested party from outside the government can petition the DEA to reschedule a drug. And that has happened twice in the context of marijuana. 2 advocacy groups, the Alliance for Cannabis Therapeutics, or ACT, and Americans for Safe Access, have both petitioned the DEA to reschedule marijuana. Those petitions were denied, and in response, they sued the DEA to try and compel the agency to change the status of marijuana. In the first case, ACT v. DEA, the court found that the anecdotal evidence that ACT relied on was insufficient to prove that marijuana was safe and effective. So ACT supplied testimony from patients who claimed that using marijuana helped ease their symptoms, and also testimony from their doctors. But the court said that was insufficient. And the court developed this 5-part test that is used to determine whether a drug has currently accepted medical use. The drug's chemistry must be well known and reproducible. There must be adequate studies showing safety. There must be adequate, well-controlled studies proving efficacy. There have to be qualified experts that accept the drug, and all of this information has to be widely available. And I believe that it's this 3rd criterion, the requirement for adequate, well-controlled studies showing efficacy, that's the most difficult obstacle to get over for petitioners that hope to reschedule a drug. And in the second case, instead of relying on anecdotal evidence, the petitioners provided peer-reviewed scientific studies. They relied particularly on a study from the Institute of Medicine, and the court said this type of evidence, though it may be better than anecdotal evidence, it's still not sufficient to satisfy that 3rd requirement of adequate, well-controlled studies. So what exactly does that mean? We're not entirely sure, But in the second case, the DEA did offer some guidance. It said that what is required is well-controlled, well-designed, well-conducted, well-documented scientific studies, and they have to be carried out in a large number of people. And I have this image that shows the different phases of clinical trials that a drug must undergo in order to gain FDA approval. And at each stage, you're looking at slightly different clinical endpoints. In some cases, earlier on, it's primarily safety. Later on, you're looking at efficacy and dosing. And at each stage, you're adding more and more participants. So it's unclear what is meant by a large number of participants. Is it the hundreds of people that would be typical of a phase 2 trial? Or is it the thousands of participants that would be typical of a phase 3 trial? It's not really clear. It's probably at least phase 2, maybe more likely phase 3. And you can see that from this language from the DEA, there are several points at which the agency could attack a study. They could say, well, we agree that you included an appropriate number of participants, but the study was not well designed, or it was not well implemented. There are several medical experts who have spoken out against exclusive reliance on randomized controlled trials in healthcare decision making. And it appears that in establishing currently accepted medical use, that's what's required, randomized controlled clinical trials. Thomas Frieden, a former head of the CDC, argued in a recent article in the New England Journal of Medicine against blind reliance on RCTs in health care decision making. Louis Lasagna, who is a very famous clinical pharmacologist and the author of a very popular modern version of the Hippocratic Oath, which is recited by thousands of new medical students across the country, argued that relying exclusively on RCTs is untenable, needlessly rigid, unrealistic, and even unethical. He cited John Christian Baylor, who was a PhD-trained statistician and also a graduate of Yale Medical School. And he said that despite some pitfalls, studies that lack internal controls can be a very valuable source of scientific information. So if we don't include information from all these other studies, case reports, observational studies, epidemiologic data, studies from other countries, we may not be looking at the full picture, and our decisions may not be providing patients with the best care. And I argue that similarly, we should not rely exclusively on controlled trials to establish whether a controlled substance has currently accepted medical use. Currently accepted medical use should be interpreted broadly to include all these other sources of data other than controlled trials, and it should be interpreted flexibly. When the FDA is deciding whether or not to approve a drug, it will sometimes reduce the amount of evidence that is required to show that a drug is safe and effective, particularly if the drug is being used to treat a serious illness with an unmet need. And I believe that a similar flexible adaptive approach should be used when deciding whether to reschedule a drug. If a Schedule I compound could be used to treat an illness like depression with suicidal ideation, post-traumatic stress disorder, or a substance use disorder, and there is an unmet need, then courts and the DEA should relax their requirements a bit in order to reschedule the drug and make it more available to researchers. So at the beginning of the talk, I defined a law as a rule generally made by a government that orders the way in which society behaves. And I said that all three branches of government create rules in a sense that control society and affect our behavior. So the rules made by the DEA and the opinions of the court that I discussed that resulted in that 5-part test, these are all sources of rules, types of law, and we need to look at them critically. If they are not addressing the needs of society, if they are not improving public health, we need to ask the question, perhaps we should revisit them, perhaps we should modify them. I want to give you one last example. Marijuana is currently listed in Schedule I, so according to the DEA, it has no currently accepted medical use. But at the same time, medical marijuana is accepted in 29 states and the District of Columbia. That number may even be larger now. It's always growing, and there are many states considering medical marijuana. There are at least 10 countries that allow medical marijuana. THC, the most well-characterized component of marijuana, is the sole active element in 2 FDA-approved medications. And the most comprehensive sort of meta-analysis of medical marijuana came out last year. It was conducted by the National Academies of Sciences, Engineering, and Medicine, concluded that adults who use medical marijuana to treat chronic pain experience a more significant reduction in pain. So taking all this evidence as a whole, we need to ask, is it accurate to say that marijuana has no currently accepted medical use? And if the current test for currently accepted medical use is inaccurate, given all this evidence, perhaps it needs to be adjusted. I think this is all very important today as we are in the midst of many public health crises. We have the opioid epidemic. We have a mental health crisis in this country. Rates of suicide are rising in teens and in veterans. And at the same time, the pharmaceutical industry has pulled back significantly its investment in new psychiatric drugs. So where is the next generation of psychiatric drugs going to come from? We may have this untapped resource in Schedule I controlled substances that are showing promise to potentially address mental illness and substance abuse. So if we condemn Schedule I drugs to that regulatory black hole and continue to erect these barriers to scientific study, we may never truly understand their risks and their potential benefits. So that's all I have, and I'm happy to take your questions. Yes?
Can you just tell us like a brief history of how opioids have managed to stay off of that list?
I'm not too familiar with that. I think a large part of it does have to do with the fact that they do have currently accepted medical uses, though. So when it comes to pain control, we don't really have much to deal with pain other than opioids, and they are very useful. I think even the most ardent critic of opioid use would still acknowledge that they have their uses in post-operative care and maybe to a lesser extent in chronic pain. That seems to be where the debate is.
Were they nowhere on that list? I was just scanning the ones that you put up. I mean, there's plenty of prescribed medications that are on there.
Right. So they are scheduled. They are not in Schedule I. There are some opioids in Schedule II. And they actually, I believe there are opioids sort of scattered throughout the schedules depending on which drug you're talking about. I think there are people who want to schedule drugs like, if not fentanyl, which obviously has some valuable uses, maybe the synthetic analogs of fentanyl. There are people who would advocate to put them into Schedule I.
What were the 5 that got taken off? How did that happen?
Oh, so that's a great question. One of them is Marinol. So that is a THC-containing drug. It actually contains little more than THC. It's just THC and maybe some sesame oil that it's suspended in. And the other drug, I don't remember the name off the top of my head. It was another THC drug. And the pharmaceutical companies that make the drugs lobby the DEA to change the scheduling. And if you actually look at the DEA list of controlled substances, it says Marinol in its FDA-approved form. So you could have an exact, a similar formulation, but it would not be, if it's not coming from the maker.
Business strategy? I thought they could melt it.
I mean, that might be one way of looking at it. I'm sure they would say it's a health, it's in the interest of people who could potentially be treated by those drugs. Yeah.
So another example is gamma hydroxybutyrate,
which is marketed as Xyrem, so it's kind of split because GHB is still Schedule 1, but Xyrem, which is a pharmaceutical product, is not. You know, even though it's the same compound.
That's a
So
great
it's kind
point.
of split, you know, in terms of scheduling.
Well, I think of THC that way because THC in its pure form is in Schedule 1. THC suspended in the sesame oil is either 2 or 3. I believe it's 3. And then THC dissolved in an alcohol solution is Schedule 2. So you really have the same active ingredient in 3 different schedules simultaneously.
So that seems to raise in my mind that there's a clear bias against plants as even being potentially medicines in the way that those 5 criteria are made, and that
Right.
you simply could not have in terms of the drug's chemistry being reproducible,
Mm-hmm.
would seem to eliminate a priori plant compounds from being considered.
That's right. You've kind of hit the nail right on the head.
And so, I mean, whether that's an influence of the pharmaceutical industry to ensure that only purified and pharmaceutical products can be marketed. I mean, I don't know how this wording came about. Do you have any sense of when did this become the definition?
So that this test originated in this case, Alliance for Cannabis Therapeutics versus DEA. So the court came up with it. They based it loosely on an 8-part test that the DEA came up with. And the court sort of whittled it down and adjusted it and said this is a better test. So this is the test that would currently be used if there was another case. And you're absolutely right. That would make it extremely difficult for the botanical form of marijuana or a psilocybin containing mushroom or any other plant like kratom or ibogaine is another plant that that would be a significant barrier.
As well as being accepted by qualified experts. That also seems like that's problematic.
I think you're right. I think you could always find some people maybe to come out of the woodwork and support you in a court case. And I think these cases are good. There are good lessons to be learned from these cases for people who are involved in future cases. I think there were some mistakes made. The fact that they relied on anecdotal testimony and
I just think it's interesting that they both have one requirement for hard, quantified evidence, but yet there's another criteria for opinion, which seems to be, well.
right. So in this case, ACT v. DEA, I believe they distinguished between the patient's like family doctor who said, "Oh, he reported to me that he took marijuana and he felt better," versus the DEA that had these renowned experts or very experienced experts who could come in and really be qualified as experts in pharmacology or drug abuse. And so there was sort of the ACT side was really at a disadvantage in that situation. So I think you could meet that criterion if you had the right experts really willing to testify to your side of the case.
I think it even goes deeper in a way about this. I keep thinking about the overlying kind of conceptually, or thinking about arbitrary and capricious. I mean, that's language that's used.
That's right.
To challenge certain decisions or government immunity, you have to prove arbitrary and capricious.
That's right.
Okay, because this is loaded throughout it, this whole history of scheduling, because there's data and then there's opinion, right? And that could always be that arbitrary capricious part. Can you go back to the criteria for the 8 for controlled substance?
Oh, sure.
Okay.
By the way, arbitrary and capricious was the standard used in this first case. The petitioners were trying to argue that the DEA had been arbitrary and capricious in its rejection of their petition.
So I've been recently doing nicotine research. So I think it's such a good example of this. Like, so where nicotine, think about that. So we just go through this, right? It's not even scheduled at all. And there's a lot of bias towards the plant itself, right? Because because it's all anchored in like nicotine, because there could be synthetic process to produce nicotine. So the FDA has new authority to regulate tobacco products. And so with e-cigarettes, well, what if you're using nicotine that's synthetic, not derived from the plant? Okay, so no, well, it's plant derived, so they use the plant to their advantage when they need to, meaning the authorities or whatever regulatory agency, right? But there could be a bias against them when it serves certain larger purposes. Again, this gets to that arbitrary nature. So think about nicotine, abuse potential. Does it have abuse potential? Okay, so does it have pharmacological effects, well characterized? Scientific knowledge of substance, decades of research. History and current pattern of abuse, yeah. Scope, duration, significance of abuse. It's a major global health problem. Public health risks, well established. Risk of psychic or physiological dependence, clear. And whether immediate precursor of an already scheduled substance, well. So 7 to 8, right, is pretty clear. It's like a poster child for Schedule 1 substance, right? Yeah. Okay, so throughout this discussion or so about this arbitrary nature, that's like so. But I think that the advocacy groups are getting more sophisticated, right? They're looking at these spaces. So where do you see a future? Like if you're going to, for anyone invested in like in a rescheduling or compassionate use, I mean, how many different pathways are there for the FDA or so for reconsidering use in a more urgent, or immediate way? I mean, there's like compassionate use, but there's different pathways, right? Could you speak to that? And if there's a group going after, advocating for that, like what do you think is the most kind of like poised or whatever to be successful? Like,
Right. I just want to comment on your nicotine example quickly. If we think about the deaths that are due to opioid overdose, you can see it's about. I think it was estimated there would be about 60,000, or last year in 2016 there were about 60,000 deaths due to opioid or drug overdose. Then the majority of those are due to opioid overdose, maybe 40-something thousand. The number of deaths each year due to tobacco is 480,000. It's almost 500,000. In fact, the deaths attributed to secondhand smoke is 40,000. So that's a great question. Why? And I mean, you can answer. This is an obvious answer, right? That there's a very sophisticated lobby to keep tobacco legal. The FDA commissioner has come out this fairly recently saying that he was making it a mission of the FDA to reduce tobacco consumption, and that is definitely a good use of agency resources, right? So in terms of the most effective way for these advocacy groups to advance their cause, I wrote about this in a paper that's going to come out in the spring in the NYU Journal of Legislation and Public Policy. It's a law review article. And I talk about different pathways to improving access to these drugs. And I think that there are a couple different ways. One way is for states to follow the example of medical marijuana. So states could technically, they don't necessarily legalize the drug. They just say, we're not going to prosecute use. And so a state could say, they just take a hands-off approach to regulating a Schedule I drug. We're not going to enforce the federal law. And there's actually a principle called the anti-commandeering principle that says that the federal government cannot force a state to enforce federal law. So let's say that, well, there are initiatives right now in 2 states, in Oregon and California, to get a ballot initiative going to legalize psilocybin. They're very different. I believe in California, the proposal is to make psilocybin legal for any use. It could be used recreationally. That's obviously more of a stretch than the Oregon initiative, which is to make it available in a more controlled setting, kind of the way that you think of psychedelics being used today, like by MAPS, like MDMA-assisted psychotherapy. It's provided in a very controlled setting. So that is one path, would be for a state to say, okay, we are no longer going to prosecute offenses for psilocybin. Then the only law enforcement that could actually arrest and prosecute would be the federal government, and they simply don't have enough resources to prosecute everyone. They could make it they could give them a really hard time. That's happened with marijuana, with the DEA coming in and arresting marijuana producers. But that is one path. Then, of course, you could go through the sort of traditional pathway of pushing a drug through the clinical trials process, and that's what MAPS is doing. And I understand there's some trials here at Yale with psilocybin, and that's sort of working within the existing framework. So I guess putting pressure on the DEA to say we want to study this drug, it has legitimate medical uses, and getting that license and running clinical trials. That is obviously very expensive. In the paper, I say that perhaps the most likely to succeed approach would be to sort of do a hybrid approach of those two. And there were some efforts to do this with ibogaine, which is a West African plant that has shown some potential to be effective in curbing addiction. There were some initiatives in New York State and Vermont to make ibogaine part of the state's opioid treatment plan. And that would have set up sort of a clinical trial that's sort of run by the state. And it was not approved. If you go and look and check on the status of those initiatives, they're in committee, which just means they're kind of lost and there's nothing happening with them. But it's a great idea. It's sort of a partnership between the state and the sort of traditional FDA approval process. And then, of course, the other option is this path of petitioning the DEA, but that doesn't seem very likely to succeed. There could be future efforts to sue the DEA. I think a suit against the DEA today for marijuana would be much more likely to succeed. We still would not have those, the randomized controlled evidence, but you could probably make a much stronger case than either of these two cases did. So there are a couple different ways, and they're all sort of being tried in some way or another. But you're right, the advocacy groups are getting more sophisticated. I have been watching the activity of this American Kratom Association, and they seem pretty sophisticated. They got that guy, Jack Henningfield, to speak on their behalf. And there is a community of kratom users who believe very strongly in that plant. And so there does seem to be some momentum there, and it will be very interesting to see what happens with that drug. Yeah.
So when individual states choose not to prosecute, whatever it is legally they need to do to essentially legalize medical marijuana or any other kind of drug, does that only impact people's ability to get it from doctors and get treated, increase our anecdotal evidence, or can it also have an impact on research on that substance, or is that sort of not impacted by individual state decisions?
That's a good question. I think that it could get very complicated with respect to research, because a lot of research is federally funded and it's being done by a university, and so the university would still be very hesitant to do that research, right? Because they could lose their federal funding. So I think that a system like that could work for making the drug available to treat people, kind of like the medical marijuana in California. When they passed the Compassionate Use Act, that made marijuana available to AIDS patients and other cancer patients and people with chronic pain conditions. So it would open up access for treatment, but maybe research might not be so successful. And that's kind of why I advocate for that hybrid approach. It's like a partnership with the state.
Could you go just forward one slide to the different pathways to rescheduling?
Oh, yeah.
So is the
Where is that?
yeah. So is what MAPS is doing, and after like going through phase 3 trials. So when they have the phase 3 data, which of these pathways is it still a petitioning that takes place with the phase 3 evidence, or it's
Yeah, I would imagine that they're trying to gather that evidence to show currently accepted medical use. And I would say that if they complete those phase 3 trials successfully and they have compelling evidence from those trials, they could make a very strong case that psilocybin or MDMA, in the case of MAPS, has currently accepted medical use. But they might still run into these other, where is that? The other factors, right? Like, no, see, they would satisfy most of these requirements. Of course, that sort of well-controlled, well-designed, well-conducted could be attacked by the DEA. It probably would be if it went that far, right? I would imagine that if MAP says, look, we have all this evidence from phase 3 trials, and they go to the DEA and petition and say, we want the scheduling changed, they'll likely encounter resistance, right? They're not just going to say, sure, you're right. And so it probably would take a lawsuit. But they would have a lot of evidence on their side. Of course, the DEA would pick apart that study and say, oh, well, it wasn't well conducted, it wasn't well designed.
It still does go through the petitioning route, you think, as opposed to one or the other?
Well, they could try to get Congress to change the scheduling. They could say, they could try to get support from members of Congress to make that change. I don't know how likely that is, but I thought it was impressive that those congressmen spoke out in support of kratom, so that could happen.
Just one other thing that's interesting, just while we're addressing like the intersection of the law, legality, and psychedelic use, is just this, just to bring up like religious freedom as another path, not to rescheduling, but a pathway to legal use of Schedule I substances, and just thinking about the cases that legalized ayahuasca within certain church contexts that went to Supreme Court decisions, and that there is, I think, something that's going to be very interesting to follow in this realm is how the blending between religious so-called use and medical use those boundaries are going to become increasingly blurred as substance users currently, are going to Mexico to receive ibogaine or whatever, or ayahuasca, but then are often ending up in these churches. So it's a religious use or a medical use.
Right.
It may not end up in rescheduling, although there's some thoughts about collecting other forms of data on this kind of use. So I don't know if you have any thoughts about it. I just think it's an interesting intersection of law and medicine that's emerging.
There are some people who argue that if someone has a mental illness, their thoughts are sort of, I'm probably adding a little of my own sort of theory in here, but some people would say that access to these drugs should be a human right. I think you could make a case, it's not really a legal case, but you can make a case that if someone has a mental illness or a substance abuse problem, their thoughts, they have certain patterns of thoughts, and maybe it is a human right that they should be able to shift that to a healthier pattern, or a pattern that they view to be more desirable.
You mentioned that as an argument for another argument, legal argument you could make.
Oh, I don't think it's really a legal argument. It's a, sort of a policy argument, I guess. It's not like you're not pointing to scientific evidence and saying, look, this is currently accepted medical use, but you're saying, look, we have millions of people who are suffer from major depression. The drugs that are currently available don't work for them. They're stuck in these patterns of addiction or suicidal ideation, and these drugs can sort of shift the way that they process information. Don't they have a right to process information the way that people without depression do? you are these drugs are available, and you're preventing them from maybe thinking that way. There's something interesting there. I think about how we're so dependent on the internet now. If you take away the internet, it really affects your day. You're like people talk about machine-brain interfaces, and we really already have that, right? Because we're so connected to our devices, the phone and computer, and so I think that in the future, I'm just saying technology has sort of affected the way information flows in your brain, and when people have disorders of consciousness or mental illnesses, they might process information differently, and you could make a case that they should be permitted to adjust that if the technology exists. Sid?
I'm struck in your presentation, it's pretty clear that scheduling is not exactly defensible either from a medical standpoint or scientific standpoint. So the question is, what is its function? Is it financial? Is it political? And what would be your thoughts on that?
I think that when you look at the rescheduling process or the scheduling process, there is a very complex interaction between multiple agencies, and they exist in they're all in the administrative branch or executive branch, but they have very different mandates. So you have the DEA, which is a law enforcement agency, and its mandate is really just to enforce that Controlled Substances Act. So they're trying to prevent diversion of drugs from legitimate sources, and they come at it from a very much of an enforcement perspective. And then you have the FDA, which is supposed to be more of a safety and public health organization, and that Controlled Substances Act was enacted in that climate of law enforcement cracking down on drug abuse and drug-related crime. So it's not a purely medical or public health enterprise. It's heavily influenced by that law enforcement perspective in which the law was created, and that's still today. I mean, the Attorney General has that power to create the schedules. So, I mean, I think it's all those things you mentioned. It's political, it's economic, it does relate to public health. I mean, I think the FDA is a good organization, and they're trying to do the right thing. So it's all those things. It's just incredibly complex.
And on that point, I think around the time that the law was coming into play, there's a lot of race relations that were, highly intertwined in that process. And,
That permeates drug regulation and addictive drug regulation for way before that as well.
Right.
The regulation of opioids, the regulation of cocaine, or the non-regulation of it, and so on. I had a different question.
Oh.
We're seeing, I think, in some of this kind of an embodiment in the law of what was considered to be the gold standard of science in medicine, which is the randomized controlled trials. So now we've got a court saying that's what you have to do. As that's being challenged, and you talked a little bit about how RCTs are being challenged, but as it's also being challenged by the fuzziness of the line that's developing between clinical and research data, and the use of large data sets, which you could sort of think of as huge piles of anecdotal evidence,
Right.
And the analysis of these data sets. How do you see that interplay changing, and do you think there's a direction there that might work in terms of how the drug studies are done, the scheduling is done, the FDA regulations are done, the whole set of everything is based on RCTs,
Yeah.
including here. How does that science get into the legal explain?
I'm not sure how data analytics will affect this, if at all, because if you look at the medical type research that's done with big data, a lot of it is really sort of junky science. It's based on correlation, and you're not really, it's interesting that this reminds me of how the DEA brings up these deaths associated with kratom. They are, it's just a correlation, and
And that's not anecdotal.
no, it's not. No, it's right. If you do an autopsy and you find kratom there, it is associated, but that doesn't mean that it's a causative factor, right? Or the causative factor. So I think that a lot of research that's being done, there's a long way to go in terms of establishing big data derived from things like social media as being truly scientifically rigorous. I mean, you can use it in public health surveillance, and you can gather epidemiologic data through online platforms like Facebook. But I'm not sure how it will actually affect. I think the court is taking such a rigid, sort of traditional, narrow view of what constitutes scientific evidence, and so I don't think it would be persuaded to include information from big data. They might consider it to be too anecdotal or correlative. Does that address your question at all? Or?
Yeah, I was also thinking about medical record data.
Yeah.
Not only social media data, but certainly what you're saying applies to the current state.
Right.
In analyzing medical record data as well. I was thinking about where this might go and how, and more generally about the interplay between, quote, science and law.
Right. So yeah, medical records would have more sort of veracity to them, but I still think that it would be hard to big data collected from medical records. They probably would still, they would view that as non-controlled, observational data, which could be very useful, right? It should be considered, but I think it would be.
Another aspect of that, though, is thinking about post-market evaluation for drugs. So that relies on reports, physicians or so, right? And so, but that informs, like, ultimately rulemaking by the FDA. So there could be a precedent, say, well, if that's good enough, right, for establishing side effects or safety, post-marketing safety and risk mitigation strategies or so, that kind of reporting, why isn't it good enough, to make a case for, a medical utility also, right? So I think the more that kind of big data approach is using, where there's more engagement with that kind of post-surveillance, where it's that kind of reporting. To prove causality, as a physician involved in research around side effects or so, it's the same, that's very difficult, yet that does have consequences that and decisions are made based on that type of data. So somewhere down the road that could be flipped, and it's, well, if it's a good enough standard there, then so I could see that potentially happening.
That's a great point.
Yeah.
One thing I had in mind too is rather than going like to take psilocybin for an example, just in seeing the list of criteria for scheduling. The current route is to try to prove that it has an accepted medical use, but it almost seems like it would be an easier case to mount the evidence that it does not meet the criteria for a controlled substance and launch a lawsuit. It seems pretty clear that it doesn't actually meet a good number of those criteria for scheduling. So
right.
I wonder if anyone's considered. Could you in theory?
Well, I think you make a great point that you could use much more anecdotal evidence to put a drug into Schedule 1, but you can't use that evidence to take it out. So it's very lopsided, right? And you could bring a lawsuit on that basis, but it would likely just be dismissed because the court is bound by these previous cases, and they would say, well, this is the test that we use, and that's the rule.
So you can't challenge a previous
You can. You could, I think you could use that as one of your arguments. You could say there's this inconsistency where the evidence required to remove a drug from being available for research and use is much lower than the evidence to take it out, and there's some injustice there.
So you're saying this is the entryway in, but you cannot,
Right.
the only way out is to show that it has an accepted medical use. You can't just say that actually it was wrongly scheduled. And
Right. You could make that argument. You could raise that argument, but I think that the other side would say, look, this is a safety risk. That's why we're scheduling the drug. They can still do. I mean, they'll say they can still do research. You can still do it. I mean, people here are doing research on Schedule I drugs, and MAPS is doing research on Schedule I drugs. So they would say, well, if you want to do research on the drug, file an application, and there's no need for it to be descheduled. So I think it's an interesting point, and you could craft an argument around it, but I don't think it would be like the primary argument you'd rest your case on. It would be more peripheral sort of argument to support your case. But I like it. So it's interesting.
Also, but the more fundamental issue is that you have the DEA. I mean, you have non-medical making decisions about medical utility, et cetera.
Right.
I mean, think about MDMA, the case of MDMA, with those administrative. I mean, the FDA's own administrative law judge, right, thought there was enough evidence that you go into Schedule III. This was in the mid '80s, but the DEA overruled that, right? I mean, they can do that, right? So
Right.
you have different agencies, right? Then
Right.
so no, and then ultimately that's non-medical. I mean, the DEA, right, or the attorney. So how likely do you think that could happen? You know, that could change. Say just reevaluating who determines how drugs are scheduled. You could say the same criteria, but
Yeah. Right. Yeah, it seems a little odd that power is placed in the hands of the Attorney General, but it's, you know.
but that was in a time like a social, embedded in a social context and time, so forth. But now,
Right.
50 years later,
Right.
is it maybe time to reevaluate that? Is anyone discussing that, even talking about that?
I really haven't seen much discussion of that, and it is
Well, we're
something.
going to get started.
I think let's get it started. Yeah, I think that's a great idea. Yeah.
How real of a path is sort of reformulation or renewed formulations as, a way around this? It sounds like those companies did with Marinol and
Right.
other things.
Right. Well, it's very realistic to do that. It's just that you have to get through those hoops. You have to get the license to do safety studies and to do clinical trials in humans and advance through the different stages. And I mean, that's what those companies did. Of course, they, if you're a larger pharmaceutical company, you might have the resources to do that. And that's available. I mean, that's what MAPS is doing with the MDMA-assisted psychotherapy in a way. I mean, it could just as easily be a pill that contains psilocybin. They would have to. I think that it's a part of the reason that they were able to get those studies approved is because they're done in a very controlled sort of environment, and they've made certain concessions to the FDA to ensure safety and to that treatment will be more tightly controlled than just a pill that you could go and fill a prescription for. But that path is a path that could be taken now. You just you have to be able to push it through the bureaucracy and get the licenses and you mean to get your drug FDA approved and then petition the DEA to change the scheduling to a less restrictive schedule?
Yeah, I guess I just wonder if whatever path that Marinol took, those administrative burdens that you discussed, if I guess I don't know the path if they sort of petition the DEA to take it off the controlled substance list and then did their clinical trial, or vice versa. And I guess depending on which path you took, it might,
So
it would
yeah,
probably just involve
you-
learning more about.
right. You so doing your research first and then getting it, the scheduling changed, versus getting the scheduling changed before you do the research, that would be more of a burden, right?
Well, it would make your trial cheaper because of all the regulatory
Oh, absolutely.
issues that you wouldn't have to deal with. But yeah, it might take.
Yeah,
forever to get it
you
done.
you wouldn't have the evidence to make this argument of currently accepted
Yeah.
use.
So Marinol must have done it the other way around. is what
Right.
you're saying.
They did the clinical testing and everything, and then they were able to argue. But obviously, having some political clout would be advantageous to sort of put pressure on the agency to do that. Any other questions?
So, sorry, the FDA has a way to, like, so how did they get it through, the people who are working on MDMA, how did they get the approvals? There must be a pathway through which they could do that. Like any experimental drug, it doesn't go into this common path, like this is an experimental drug for this particular illness and then go down that path? Or is it like, is there a separate path for potentially abusable kind of drugs? Or is it all the same kind of approval pathway to get a drug into like the trials process?
There are some alternative paths that you can take. So sort of those examples I was giving about if you're trying to treat a serious illness with an unmet need, sometimes you can take a shortcut and you can petition the FDA to grant you fast track approval or breakthrough status. And that actually happened with the MDMA assisted therapy. They were able to get breakthrough status granted on that, and so that just shaves some time off of the the overall approval process. And Johnson & Johnson did that as well with S-ketamine, this isomer of ketamine that they are marketing for treating major depression with suicidal ideation. So there are certain shortcuts you can take through the FDA, but really everything has to go through that process with the four phases of clinical trials.
Right. The public health kind of
like
burden
it's
and
it's a trial of MDMA for the treatment of
Right.
It's a trial of that for the treatment of that. Yeah.
Right, that's a good point. It's not just the substance, right?
It's not like there's MDMA trials. It's
Right.
You're trying to treat some illness and you are trying this
Right, the public health burden,
drug,
yeah.
and then it's just if it happens to be Schedule 1, it's that much harder to go through the regular.
That's right. Yeah. I mean, clearly it can be done. It's just that I think it really narrows the opportunities to do research.
I mean, the other thing that I find kind of interesting about psychedelic assisted psychotherapy is that they really represent a new paradigm in terms of how we approach treatment. There's no other model that I know of where we're using a drug to enhance psychotherapy. So MDMA or psilocybin, whichever one is being studied, is in conjunction with psychotherapy. So when MDMA, if it's going to get be scheduled, it will be MDMA and psychotherapy as one entity. It's not just the MDMA itself. So that's a really important point to make. And there's no ketamine-assisted psychotherapy. There's no Prozac-assisted psychotherapy. And I know Rick pretty well, and he really thought that would actually be viewed more favorably. That we talk about psychedelics, but it's the psychotherapy that we're actually trying to enhance and facilitate. And we forget to talk about that component, but it is an integral part of the treatment. It's an MDMA-assisted psychotherapy. So that is the thing that is being evaluated as opposed to just the MDMA.
Right. No, that's a great point. It's easy to forget that.
It's easy to forget.
I think that when these studies are reported in the media, sometimes that's not really emphasized.
Yeah.
And that definitely has been advantageous for them.
Yes, absolutely.
It's also kind of overlooked because
Yeah.
of a repressed history of work with LSD, which went on for decades, really. In the 50s and in the 60s. and it was always thought of, it wasn't the drug, it was the enhancement of either, repressed material, whatever. I mean, you gotta think about it as like analytic school of thought. I mean, there's certain assumptions built, but it was always not the drug itself, it was the experience, right, and what it elicited in the context there. But because all that's been kind of repressed and erased, or no one learns about it, it's not part of the curriculum. You learning about that in psychiatry? So you say, well, the ethics and kind of the study design, the methodology wasn't up to like current standards, and that's true. But there's still a lot of data and a lot of observations that could be pulled from all that, but it's not been really evaluated. And so that's been forgotten also. That it wasn't just the LSD experience, it was the relational aspect, it was to enhance therapy.
And I think this is, the reason why those studies were looked at, less well-designed studies is because they really tried to, they were portrayed as you're trying to enhance the placebo effect. So whenever you brought it up against randomized controlled trials, they said, well, how could you actually say that this is not a result of a placebo effect or a non-specific effect? So I think what MAPS has actually done is has really flipped that on its head and said, and I think this is what makes double-blind placebo-controlled studies kind of difficult to honor the integrity of double-blind in psychedelic research, is that it's very obvious who's getting the drug. But Rick has been very specific about that. Said, no, this truly represents a new paradigm where we are going to integrate the non-specific placebo effects in a way that they are reliably generalizable. So this is very different from the way we've been doing pharmacological studies, where we try to isolate pharmacological studies, like we give some ketamine and close the curtains. No, we are enhancing all the non-specific effects. And so a lot of people actually have a problem with that, with that very model. So it will be very interesting when the phase 3 data will be actually presented before FDA, and how they will actually, how that will be criticized or will be considered.
It will be very interesting.
It will be very interesting. It'll be a totally new paradigm.
Absolutely.
Yeah.
It would be hard to. Obviously, you're right. Like they're not just going to approve MDMA, remove it from the schedule.
That's right.
It would have that asterisk only as FDA approved. With these conditions.
Yeah.
And I think if they get really good results, it could be difficult to shut that down.
Yeah.
So I mean, it'll be riveting to see the response.
So I think for at least the way the psilocybin phase 3 trials are being designed, from speaking to the USONA folks, they're basically trying, for the purposes of the FDA or the DEA, trying to. I think they have the same kind of approach, but they're trying to make it sound as if they're not really providing the psychotherapy. It's like just a minimum support, just like a minimum supportive role. So they're trying to make it sound for the agency like it's a drug study, when really it's not.
Yeah.
This is weird, because in theory afterwards, like it has to be provided with the therapy, but they're minimizing it for the purposes of the agency, at least more for psilocybin, but I think.
Thank you. It's a great discussion.
Thank you.